There's a personnel mechanism called the Intergovernmental Personnel Act assignment. It appears in federal law under Section 3371 of Title V of the U.S. Code, and since 1970 it has allowed federal agencies to pay the salaries of people working inside congressional offices, completely off the books of Congress's own payroll. No hearing announced this. No press release explained it. It simply sits there in the statute books, still running today. Here's what it literally is. An employee of a federal agency, the FDA, the Pentagon, the EPA, doesn't matter which, gets detailed to work inside a congressional office or committee. They sit at a Hill desk. They draft memos, shape legislation, brief members, but their paycheck never comes from the House or Senate. It keeps coming from the agency they supposedly left behind. On paper, they never stopped being that agency's employee. That's the whole trick. Congress gets the labor. The agency keeps the leash. It didn't start as a scandal. In 1970, lawmakers wanted a narrow tool, a way to swap expertise between federal, state, and local government, so a scientist in Washington could spend a year advising a state health department, or vice versa. That's the version that got voted on. But the expansion into routine congressional staffing happened somewhere else entirely, inside internal administrative rules set by the House Committee on Administration and its Senate counterpart, bodies that approve staffing arrangements office by office, assignment by assignment, with no floor vote and no public tally of how many exist right now. The tool grew. The vote never followed it. And remember, no one voted for this. Not once, not for any specific deedily sitting in any specific office today. That's worth sitting with because it changes who's actually writing your laws. Here's who controls it now. The agencies being watched are frequently the ones supplying the watchers. A committee overseeing pharmaceutical regulation can be staffed in part by someone still drawing a health and human services paycheck. A committee reviewing defense contracts can lean on an analyst whose salary still originates inside the Pentagon. The people evaluating an agency's conduct are, in some cases, financially tethered to that same agency the entire time they're doing it. Picture the actual mechanics. A regulation affecting a drug your family takes gets drafted with input from a staffer detailed from the very agency that approved that drug. Their performance review, their next promotion, their career trajectory, all of it still runs through the agency, not through Congress. So when that staffer chooses which studies to cite, which language to soften, which provision to quietly drop from a bill, they're doing it while still employed by the institution with a stake in the outcome. You never see their name. Disclosure rules don't require agencies to publish a running list of who's detailed where, or for how long, or why. The paper trail that would let you check this yourself was never built. And here's the part that should actually worry you: it's completely legal. Not a loophole being exploited in the shadows. Not an oversight anyone's trying to hide guiltily. It's a fully sanctioned, statute-backed, decades-old arrangement that Congress uses on purpose because it's convenient. Free expertise paid for by someone else's budget. Nobody broke a rule. The rule was built to allow exactly this. Why can't it be repealed? Because it isn't concentrated anywhere. There's no single office, no single program, no single line item that a future Congress could strike down in one vote. It's distributed, hundreds of individual assignments across hundreds of individual offices, each approved administratively, each invisible unless someone goes looking case by case. Ending it would require every chamber committee and every federal agency to simultaneously give up a staffing tool they've relied on for over 50 years. No single actor has both the authority and the incentive to do that. The lock isn't legal, it's structural. It survives by being everywhere and nowhere at once, which raises the uncomfortable question about everything else Congress touches. If the bodies meant to oversee federal agencies can be quietly staffed by those same agencies, what does oversight even mean anymore? Every hearing, every report, every piece of legislation that claims independence from the agencies it regulates. How much of that independence is real, and how much is borrowed staff wearing a different badge for a few years before rotating back home? This isn't one broken office. It's a structural question about whether the referee and the player were ever fully separate to begin with. So the next time you hear that a congressional committee found no wrongdoing in an agency it was supposed to be scrutinizing, ask yourself something simple. Who was sitting in that room writing the findings, and who was still signing their paycheck the whole time?